Rule 7. Parts and contents of a pleading. Section 1. Caption. The caption sets forth the name of the court, the title of the action, and the docket number if assigned. The title of the action indicates the names of the parties. They shall all be named in the original complaint or petition, but in subsequent pleadings, it shall be sufficient if the name of the first party of each side be stated with an appropriate indication when there are other parties. Their respective participation in the case shall be indicated. In other words, caption contains the following: 1. The name of the court, 2. The title of the action, and 3. The docket number if assigned. Body sets forth its designation, the allegation of the party claims and defenses, 3. The relief prayed for, and the date of the pleading. So there must be a caption, title. Take note, the title of the action indicates the names of the parties. They shall all be named in the original complaint or petition, but in the subsequent pleadings, it shall be sufficient if the name of the first party of each side be stated without the others. You only write the first name of plaintiff and defendant and followed by the word et al. Suppose there are 20 plaintiffs and 20 defendants in the concept of permissive joinder of parties. Is it necessary that they shall be named? In the complaint, yes, they shall all be named. It is possible that the title alone will reach 3 or more pages. But in subsequent pleadings like the answer, reply, it is not necessary to write the name of everybody. What the law requires is to write the name of the first plaintiff, followed by the term et al. Example, Miss Kitan et al. Plaintiffs versus Miss Pastor et al. Defendants. So the rule is, it is only in the complaint where the name of all the parties are required to be stated. But in subsequent pleadings, no need. But there is an exception to this rule. There are instances where the law does not require the name of the parties to be stated, even in the complaint. What are the instances where the law does not require the name of the parties to be stated even in the complaint or pleading? These are the following: 1. Subsequent pleading, example, answer, reply. 2. Class suit, Rule 3, Section 12. 3. When the identity or name of the defendant is unknown, Rule 3, Section 14. 4. When you sue an entity without judicial personality, Rule 3, Section 15. 5. If a party is sued in his official capacity, official designation is sufficient. Example, Mr. Acelarvis, the city mayor of Davao, Unavia versus city mayor, 99 Phil 253. Variance between caption and allegations in the pleading. It is not the caption of the pleading, but the allegations therein which determine the nature of the action, and the court shall grant relief warranted by the allegations and proof, even if no such relief is prayed for. Solid Homes versus CA, Banco Filipino versus CA, and Lorbes versus CA. Thus, a complaint captioned as unlawful detainer is actually an action for forcible entry, where the allegations show that the possessor of the land was deprived of the same by force, intimidation, strategy, threat, or stealth. Likewise, a complaint for unlawful detainer is actually an action for collection of sum of money, where the allegations of the complaint do not disclose that the plaintiff demanded upon the defendant to vacate the property, but merely demanded to pay the rentals in arrears. In one case, while the complaint was denominated as one for specific performance, the allegations of the complaint and the relief prayed for actually and ultimately sought for the execution of a deed of conveyance to effect a transfer of ownership of the property in question. The action, therefore, is a real action. Gotchan versus Gotchan, 372 Squaw 256. Also, although the complaint was denominated as one for reformation of the instrument, the allegations of the complaint did not preclude the court from passing upon the real issue of whether or not the transfer between the parties was a sale or an equitable mortgage, as the said issue has been squarely raised in the complaint and had been the subject of arguments and evidence of the parties. Lorbes v. CA 351-716. If the petitioner filed before the Supreme Court a petition captioned Petition for Certiorari based on Rule 65, but the allegations show that the issues raised are pure questions of law, the cause of action is not one based on Rule 65, which raises issues on jurisdiction, but on Rule 45, which raises pure question of law. The allegations of the pleading determine the cause of action and not the title of the pleading. De Castro v. Fernandez, GR 155041. Section 2. The body. The body of the pleading sets forth its designation, the allegations of the parties' claim or defenses, the relief prayed for, and the date of the pleading. Paragraph. The allegations in the body of a pleading shall be divided into paragraphs, so numbered as to be readily identified, each of which shall contain a statement of a single set of circumstances so far as that can be done with convenience. A paragraph may be referred to by its number in all succeeding pleadings. Headings. When two or more causes of action are joined, the statement of the first shall be prefaced by the words first cause of action, of the second by second cause of action, and so on for the others. Relief. The pleading shall specify the relief sought, but it may add a general prayer for such further or other relief as may be deemed just or equitable. The date. Every pleading shall be dated. In the body, you state your allegations or defenses. Then at the end, you state the relief, which is also called prayer, what you are asking the court. Wherefore it is respectfully prayed that judgment be rendered ordering defendant to pay plaintiff his loan of 1 million with interest of 10% per annum from this date until fully paid. Then you end up with the date of the pleading, Baguio City, Philippines, December 10, 2017. A pleading is divided into paragraphs so numbered as to be readily identified. Normally, a complaint starts, plaintiff through counsel respectfully alleges that. Then first paragraph, second paragraph, and so on. The first paragraph is normally the statement of the parties and their addresses, which is required under Rule 6, where a complaint must state the names. 1. Plaintiff Juan de la Cruz is of legal age, a resident of Baguio City, whereas defendant Pedro Bautista is also of legal age and a resident of Baguio City. 2. On such and such a date, defendant secured a loan from plaintiff in the amount of so much payable on this date. 3. The loan is now overdue, but defendant still refused to pay. So every paragraph is numbered so that it can easily be identified in the subsequent pleadings. So in his answer, the defendant will just refer to number 1, 2, 3. I admit the allegations in paragraph number 5. Paragraph B is related to Rule 2 on joinder of causes of action. Can you file one complaint embodying 2 or more causes of action? Yes. Example: Angela wants to file a case against Ina to collect 3 unpaid promissory notes. So there are 3 causes of action. The lawyer of Angela decided to file only one complaint collecting the 3 promissory notes. Now, how should he prepare the complaint containing the 3 promissory notes? Plaintiff respectfully alleges 1. That he is of legal age. First cause of action. In 2017, there was a loan secured amounting to so much and it is not paid until now. Second cause of action. In 2018, there was a second loan, became payable and is not paid. Third cause of action, etc. So you indicate your different causes of action. That is how you prepare your complaint. On the other hand, the defendant will answer. Answer to the first cause of action. Answer to the second cause of action. Answer to the third cause of action. Do not combine them together in one paragraph. Even in trial, when you present your exhibits, you might get confused because you combine all the three causes of action in one paragraph. But with this one, the presentation is clear, the outline is clear, and it is more scientifically arranged than joining them in one story. Under paragraph C, the pleading must state the relief sought, but it may add a general prayer for such further other relief as may be just and equitable, like the relief prays for such further or other relief which the court may deem just or equitable. The relief or prayer, although part of the complaint, does not constitute a part of the statement of the cause of action. It does not also serve to limit or narrow the issues presented. UBS versus CA 332 Square 534. It is the material allegations of the complaint, not the legal consequences made therein, or the prayer, that determines the relief to which the plaintiff is entitled. Banco Filipino versus CA 332 Square 241. It is important to remember that the court may grant a relief not prayed for as long as the relief is warranted by the allegations of the complaint and the proof. Lorbes versus CA. Is a prayer or relief part of the main action? No, it is part of the complaint or answer, but it may indicate what is the nature of the cause of action. Cause of actions are mere allegations. Prayer is not part of the action, but it is important because it might enlighten us on the nature of the cause of action. That is the purpose of relief or prayer. Example: Angela filed a case against Ina for annulment of a contract of sale. If you look at the caption, it is a personal action which should be instituted in the place where the parties reside. But if you look at the prayer, wherefore it is respectfully prayed that after trial, the deed of sale shall be annulled on the ground of intimidation, and the ownership of the land sold to the defendant, and diggers be ordered returned. Actually, you are trying to recover the ownership of the land. So in other words, it is not a personal action, but a real action. Section 3, signature and address. Every pleading must be signed by the party or counsel representing him, stating in either case his address, which should not be a post office box. Signature and address. Every pleading must be signed by the party or the counsel representing him. A signed pleading is one that is signed either by the party himself or his counsel. Section 3, Rule 7 is clear on this matter. It requires that a pleading must be signed by the party or counsel representing him. Therefore, only the signature of either the party himself or his counsel operates to validly convert a pleading from one that is unsigned to one that is signed. Republic versus Kendrick Development 351 Squaw 716. It has been held that counsel's authority and duty to sign a pleading are personal to him. He may not delegate it to just any person because the signature of counsel constitutes an assurance by him that 1. He has read the pleading, 2. That to the best of his knowledge, information, and belief, there is a good ground to support it, and 3. That it is not interposed for delay. Under the rules of court, it is counsel alone, by affixing his signature, who can certify to these matters. The preparation and signing of a pleading constitute legal work involving practice of law, which is reserved exclusively for the members of the legal profession. Accordingly, however, counsel may delegate the signing of pleading to another lawyer, but cannot do so in favor of one who is not. In so ruling, the court cites the Code of Professional Responsibility, the pertinent provision on which provides Rule 901, a lawyer shall not delegate to any unqualified person the performance of any task which by law may only be performed by a member of the bar in good standing. A signature by agents of a lawyer amounts to signing by unqualified persons, something the law strongly prescribes. Therefore, the blanket authority entrusted to just anyone is void. Any act taken pursuant to the authority is likewise void. Hence, there is no way it could be cured or ratified by counsel. Republic versus Kendrick Development Company. Also, take note of the prohibition now. You must state your address, which should not be a post office box, because one difficulty is that the exact date when you claim your mail cannot be determined if it is a P.O. box. If it is served to your office, the exact date can easily be determined. Oh, and by the way, I'd like to appreciate you. I'm grateful that you stumbled into my channel and you're listening to it. Please do me a favor and hit that subscribe button. It is totally free. It makes me really feel good doing all these. Thank you. Bar question. What is the meaning of the phrase implied certification in the pleading? Implied certification in the pleading means that when the lawyer signs the pleading, he is certifying that he has read it to the best of his knowledge, information, and belief there is a good ground to support it, and it is not interposed for delay. Section 3, last paragraph. An unsigned pleading produces no legal effect. However, the court may, in its discretion, allow such deficiency to be remedied if it shall appear that the same was due to mere inadvertence and not intended for delay. Counsel who deliberately files an unsigned pleading or signs a pleading in violation of this rule, or alleges a scandalous or indecent matter therein, or fails to promptly report to the court a change of his address, shall be subject to appropriate disciplinary action. So when a pleading is not signed, it produces no legal effect. It is as if no pleading has been filed. Now, suppose it was just an inadvertent omission. It was not intentional, maybe because he was hurrying to file the pleading. The lawyer had it filed when actually he has not signed it. If it was done in good faith, the court may forgive the counsel because the law says, however, the court may, in its discretion, allow such a deficiency to be remedied if it shall appear that the same was due to mere inadvertence and not intended for delay. So you sign it now in order that it will produce a legal effect. However, if the lawyer files a pleading which is unsigned deliberately, then according to the rules he shall be subject to appropriate disciplinary action. That is not only practically unethical, but he will also be subject to disciplinary action if he signs a pleading in violation of this rule, or alleges scandalous or indecent matter therein, or fails to promptly report to the court a change of his address. Now, this ground, fails to promptly report to the court a change of his address, has been inserted in the 1997 rules. This was not found in the prior rules, perhaps to prevent delays. Signature of a disjoined party. The court rules that the absence of the signature of the person misjoined as a party plaintiff in either the verification page or certification against form shopping is not a ground for the dismissal of the action. There is no judicial precedent affirming or rejecting such a view, but we are comfortable with making such a pronouncement. A disjoined party plaintiff has no business participating in the case as a plaintiff in the first place, and it would make little sense to require the disjoined party in complying with all the requirements expected of plaintiff. Chua versus Torres, GR 151-900. Verification. Verification except when otherwise specifically required by law or rule. Pleadings need not be under oath, verified, or accompanied by affidavit. A pleading is verified by an affidavit that the affiant has read the pleading and that the allegations therein are true and correct of his knowledge and belief. A pleading required to be verified which contains a verification based on information and belief, or upon knowledge, information, and belief, or lacks a proper verification, shall be treated as an unsigned pleading. What do you understand by verification in a pleading? It means that there is an affidavit accompanying the pleading, that the pleader will certify that he prepared the pleading, that all allegations therein are true and correct. For example, in the pleading, the plaintiff will say, I, Juan de la Cruz, of legal age, after being sworn in accordance with law, hereby say that I am the plaintiff in the above entitled case. I caused the preparation of this complaint. I read the allegations therein, and they are true and correct to my own knowledge. Signed, Affiant. Subscribed and sworn to before me on this second day of October 2017 in the city of Baguio, Philippines. A. Miss Domi, Notary Public. The pleader, whether plaintiff or defendant, will attest that the allegations in his complaint or in his answer are true and correct of his own knowledge, and then he will sign it, and then below that there will be the so-called jurat, subscribed and sworn to before me on this day of December 2017 in the city of Baguio, Philippines, then signed by the notary public, meaning statements in the pleading are confirmed to be correct under oath by the defendant. That is called the verification of a pleading. How is a pleading verified? A pleading is verified by an affidavit. This affidavit declares that A. The affiant has read the pleading and that the allegations therein are true and correct of his personal knowledge or based on authentic records. Section 4 as amended by AM number 00210 May 1, 2000. Significance of verification. The purpose of verification is to ensure good faith in the averments of a pleading, or are true and correct, not merely speculative. Sarmiento versus Saratan. Effect of lack of verification. Lack of verification in the pleading is a formal defect, not jurisdictional defect, and can be cured by amendment. Philippine Bank of Commerce versus Makadaeg. The absence of a verification may be corrected by requiring an oath. The rule in keeping with the principle that rules of procedure are established to secure substantial justice and that technical requirements may be dispensed with in meritorious cases. Pampanga Sugar Development Company versus NLRC 272-737. The court may order the correction of the pleading or act on an unverified pleading if the attending circumstances are such that strict compliance would not fully serve substantial justice, which after all is the basic aim for the rules of procedure. Robert Development Corporation versus Kitane. Josen versus Torres 290-279. What do you think will happen if a pleading is verified by a party and it turns out that the allegations are false, and that he deliberately made those allegations false and under oath? That will be a ground for the prosecution for the crime of perjury, because that is a false affidavit. But if the pleading is not verified, even if there are false, there is no perjury, because perjury requires a sworn statement by the accused. Does the law require every pleading to be verified? No. The general rule is pleadings need not be under oath, except when otherwise specifically required by law or this rule. When the law or rules require pleading to be verified, then it must be verified, otherwise it is formally defective. If the law is silent, verification is not necessary and the pleading is filed properly. Verification, when required, is intended to secure an assurance that the allegations of a pleading are true and correct, are not speculative or merely imagined, and have been made in good faith. To achieve this purpose, the verification of a pleading is made through an affidavit or sworn statement confirming that the affiant has read the pleading, whose allegations are true and correct of the affiant's personal knowledge or based on authentic records. However, the rules do not require the litigants to read the very same document that is to be filed before the court. What the rules require is for a party to read the contents of a pleading without any specific requirement on the form or manner in which the reading is to be done. The variance between the dates of the petition and the verification does not necessarily lead to the conclusion that no verification was made or that the verification was false. Spouses Valmonte versus Alcala, GR 168667. Bar question: name as many pleadings as you can which must be verified. The following. Rule 8. When you deny the due execution of an actionable document. 2. Summary rules. All pleadings under summary rules should be verified. 3. Special civil actions. Petition for certiorari, prohibition, and mandamus. 4. Statement of claim for small claims cases as well as the response thereto. Sections 5 and 11. Procedure for small claim cases. 5. Complaint for injunctions. Section 4, Rule 58. Application for appointment of receiver, Section 1, Rule 59. Application for support pendentally, Section 1, Rule 69. Petition for forcible entry or unlawful detainer, the answers thereto, and the answers to any compulsory counterclaim and cross-claim pleaded in the answer, Section 4, Rule 70. Petition for indirect contempt, Rule 4, Rule 71. Petition for relief from judgment or order, Section 3, Rule 38. Petition for review from the RTC to the Supreme Court, Section 2, letter C, Rule 41. Petition for review from RTC to Supreme Court, Section 1, Rule 42. Petition for review from CTA and other quasi-judicial agencies to the CA, Section 5, Rule 43. Appeal by certiorari under Rule 45 from CA to Supreme Court, Rule 1 of Rule 45. Petition for appointment of a guardian, Section 2, Rule 93. Petition for leave filed by guardian to sell or encumber property of an estate, Rule Section 1, Rule 95. Petition for declaration of competency of a ward, Section 1, Rule 97. Petition for habeas corpus, Section 3, Rule 102. Petition for change of name, Section 2, Rule 103. Petition for voluntary judicial dissolution of a corporation, Section 1, Rule 105. Petition for cancellation or correction of entries in the civil register, Section 1, Rule 108. On the other hand, suppose a pleading does not require verification, but the lawyer had it verified. What is the effect? There is no effect, just surplusage. A pleading in general is not required to be verified, but if the lawyer verified it, is there something wrong with it? Technically none. But if it is required to be verified and you omit the verification, it is formally defective. Certification of non-form shopping, Section 5. And Section 5, certification against form shopping. The plaintiff or principal party shall certify under oath in the complaint or other initiatory pleading asserting a claim for relief, or in a sworn certification annexed thereto and simultaneously filed therewith, a. that he or she has not theretofore commenced any action or filed any claim involving the same issues in any court, tribunal, or quasi-judicial agency, and to the best of his or her knowledge, no such other action or claim is pending therein. B. If there is such other pending action or claim, a complete statement of the present status thereof. And C. If he or she should thereafter learn that the same or similar action or claim has been filed or is pending, he or she shall report that fact within 5 calendar days therefrom to the court wherein his or her aforesaid complaint or initiatory pleading has been filed. The authorization of the affiant to act on behalf of a party, whether in the form of a secretary's certificate or special power of attorney, shall be attached to the pleading. Failure to comply with the foregoing requirements shall not be curable by mere amendment of the complaint or other initiatory pleading, but shall be cause for the dismissal of the case without prejudice, unless otherwise provided upon motion and after hearing. The submission of a false certification or non-compliance with any of the undertakings therein shall constitute indirect contempt of court without prejudice to the corresponding administrative and criminal actions. If the acts of the party or his or her counsel clearly constitute willful and deliberate form shopping, the same shall be ground for summary dismissal with prejudice and shall constitute direct contempt, as well as cause for administrative sanctions. Section 6 contents every pleading stating a party's claims or defenses shall, in addition to those mandated by Section 2, Rule 7, state the following. A. Names of witnesses who will be presented to prove a party's claim or defense. B. Summary of the witnesses' intended testimonies, provided that the judicial affidavits of said witnesses shall be attached to the pleading and form an integral part thereof. Only witnesses whose judicial affidavits are attached to the pleading shall be presented by the parties during trial, except if a party presents meritorious reasons as basis for the admission of additional witnesses. No other witness or affidavit shall be heard or admitted by the court. And C. documentary and object evidence in support of the allegations contained in the pleading. The certification is mandatory under Section 5 of Rule 7, but not jurisdictional. Robert Development Corporation versus Kitane. This rule applies as well to special civil actions, since a special civil action is governed by the rules for ordinary civil actions, subject to the specific rules prescribed for a special civil action. Such specific rule appears under Rule 46, Section 3, which requires that every petition for certiorari to be accompanied by a sworn certification of non-forum shopping. Waknang versus Comelec, GR 178024. Meaning of forum shopping. This is forum shopping when, as a result of an adverse opinion in one forum, a party seeks a favorable opinion, other than by appeal or certiorari, in another. There can also be a forum shopping when a party institutes two or more suits in different courts, either simultaneously or successively, in order to ask the court to rule on the same or related causes and or to grant the same or substantially the same relief on the same supposition that one or the other court would make a favorable disposition or increase a party's chance of obtaining a favorable decision or action. Hui Bon Hao versus Conception, GR 153785, 2006. Heirs of Cesar Marasigan versus Marasigan, GR 156078. It is an act of a party against whom an adverse judgment has been rendered in one form of seeking and possibly getting a favorable opinion in another form, other than by appeal or the special civil action of certiorari, or the institution of two or more actions or proceedings grounded on the same cause, on the supposition that one or the other court would make a favorable disposition. Espouses Carpio versus Rural Bank of Santo Tomas, Batangas, GR 153171. The rationale against forum shopping. The rationale against forum shopping is that a party should not be allowed to pursue simultaneous remedies in two different forms. Filing multiple petitions or complaints constitutes abuse of court processes, which tends to degrade the administration of justice, wreaks havoc upon orderly judicial procedure, and adds to the congestion of the heavily burdened dockets of the court. Thus, the rule prescribing forum shopping seeks to promote candor and transparency before the courts, to promote the orderly administration of justice, prevent undue inconvenience upon the other party, and save the precious time of the courts. It also aims to prevent the embarrassing situation of two or more courts or agencies rendering conflicting resolutions or decisions upon the same issue. Hui Bon Hao versus Conception, Supra. To determine whether there is forum shopping, the test is to see whether in the two or more cases pending, there is A. Identity of parties, B. Identity of rights or causes of action, and C. Identity of reliefs sought. Who executes the certification? It is the plaintiff or principal party who executes the certification under oath, Section 5. The certification must be executed by the party, not the attorney. Damasco versus NLRC. It is the petitioner and not the counsel who is in the best position to know whether he or it actually filed or caused the filing of a petition. A certification signed by counsel is a defective certification and is a valid cause for dismissal. Far Eastern Shipping Company versus CA. This is the general and prevailing rule. Liberal interpretation of the rule. It has also been held that the rules on forum shopping, which were precisely designed to promote and facilitate the orderly administration of justice, should not be interpreted with such absolute literalness as to subvert its own ultimate and legitimate objective, which is the goal of all rules of procedure, that is, to achieve substantial justice as expeditiously as possible. Great Southern Maritime Services versus Acuna. Hence, the rule is subject to the power of the Supreme Court to suspend procedural rules and to lay down exceptions to the same. In appeal by certiorari to the Supreme Court, the lack of certification is generally not curable by the submission thereof after the filing of the petition. Section 5, Rule 45 of the 1997 Rules provides that failure of the petitioner to submit the required documents that should accompany the petition, including the certification required in Section 4, Rule 45, shall be sufficient ground for the dismissal thereof. Exceptions. In certain exceptional circumstances, however, the court has allowed the belated filing of the certification. In all these cases, there were special circumstances or compelling reasons that justified the relaxation of the rule. The same liberal construction applies to certifications against forum shopping signed by the person on behalf of a corporation, which are unaccompanied by proof that said signatory is authorized to file a petition on behalf of the corporation. A liberal interpretation is given to the rule, more so where the petitioner did submit a certification against forum shopping, but he failed only to show proof that the signatory was authorized to do so. In several cases, Shipside Incorporated versus CA, Ateneo de Naga University versus Manalo, the court permitted the subsequent submission of proof of authority to sign the certification against forum shopping. A juridical entity, unlike a natural person, can only perform physical acts through properly delegated individuals. The certification against forum shopping, where the plaintiff or a principal party is a juridical entity like a corporation, may be executed by a properly authorized person. This person may be the lawyer of the corporation as long as he is duly authorized by the corporation and has personal knowledge of the facts required to be disclosed in the certification against forum shopping. The certification may be signed by the authorized lawyer. National Steel Corporation versus CA. A board resolution purporting to authorize a person to sign documents on behalf of the corporation must explicitly vest such authority. The signing of certifications and verifications against forum shopping is not integral to the act of filing. This may not be deemed as necessarily included in an authorization merely to file cases. MCWD versus Margarita Adala, GR 168914. The certification against forum shopping is mandatory in filing a complaint and other initiatory pleadings asserting a claim. These initiatory pleadings include not only the number 1 original complaint but also 2 permissive counterclaim, 3 cross-claim, 4th, 3rd, 4th party complaint, and 5 complaint in intervention, 6 petition of any application in which a party asserts a claim for relief. The rule does not require a certification against forum shopping for a compulsory counterclaim because it cannot be the subject of a separate and independent adjudication. It is therefore not an initiatory pleading. UST versus Surla, 294 SCRA 382. It bears stressing that the rule distinctly provides that the required certification against forum shopping is intended to cover an initiatory pleading, meaning an incipient application of a party asserting a claim for relief. The answer with a counterclaim is a responsive pleading filed merely to counter petitioner's complaint that initiates the civil action and is a claim for relief that is derived only from or is necessarily connected with the main action or complaint. It is not an initiatory pleading. Spouses Carpio versus Rural Bank of Santo Tomas, Batangas. What is the effect of non-compliance? The failure to comply with the required certification is not curable by a mere amendment and shall be a cause for the dismissal of the action. The dismissal is not to be done by the court motu proprio, as the rule requires that it shall be done upon motion and after hearing. The dismissal is as a rule without prejudice, unless the order provides otherwise. What is the effect if a complaint or a third-party complaint is filed in court without the certification of non-forum shopping? That is a ground by itself for an automatic dismissal of the complaint. Other requirements: all pleadings, motions, and papers filed in court by counsel shall bear, in addition to counsel's current professional tax receipt number or PTR, counsel's current IBP official receipt number indicating its date of issue. Pleadings, motions, and papers which do not comply with this requirement may not be acted upon by the court without prejudice to whatever disciplinary action the court may take against the erring counsel, who shall likewise be required to comply with the requirement within 5 days from notice. And that concluded Rule 7. Please don't forget to hit that appreciation button, spells subscribe. Thank you.